Did you know that in Texas at one point it was illegal to conceal carry wire cutters? Now I'm not sure if this is still in effect today or if it was updated at some point, but allegedly it came from a time when ranchers disputed over open ranges versus fencing off their land. And so instead of addressing who was right, the law just prevented ranchers from cutting each other's fences by making it illegal to carry wire cutters. Now, much like every other state, Texas eviction laws vary from county to county, and this is in terms of proceedings, formatting requirements, etc., etc. Now, despite that, they all follow the same general process, which is fill out the forms, serve the tenant, attend the trial, and wait for judgment. Every eviction process is different and completely dependent on the lease/rental agreement signed by the tenant and the landlord, so it's always best to exercise meticulous file keeping to avoid errors that could be exploited by the tenant. Now, this video will give you a detailed summary to refer to when you are evicting a tenant. Just make sure to confirm procedures with your county to make sure the entire process goes as smoothly as possible, and please remember, I am not an attorney. I did not go to law school, so if you have any questions about your specific case, I would highly recommend you contact an attorney in your area to help you out. Now, rent is usually considered late a day past its due date. A grace period may be available if it is stated in the lease/rental agreement. But before a landlord can start the eviction process, they are required to give the tenant an official written notice to vacate. This is also known as a 3-day notice to pay or quit. Now, if the tenant does pay that rent within those 3 days, then the eviction process does not continue. If the tenant is unable to pay, then the landlord reserves the right to offer them a second chance. In the state of Texas, landlords are not obligated to offer a second chance. Once the 3 days are up, they can proceed with the eviction process immediately. Now, landlords can charge tenants a late fee, but they must provide a grace period of at least 2 days. The late fee provision also has to be stated within the lease/rental agreement. The agreement has to be upheld by both the tenant and the landlord for the entire duration of the tenant's stay. Now, keep in mind that agreements may vary from tenant to tenant, but if a tenant does violate any terms from the lease agreement, the landlord must issue a 3-day notice to cure violations or move out. If the tenant resolves the issues on time, then the eviction process does not continue. Some of these lease violations may include staying longer than indicated on the lease, disturbing other tenants with loud activity, damaging the rental property itself, smoking in non-smoking areas, or keeping pets in pet-free properties. If the tenants fail to resolve the violations on time, then the landlord may continue with the eviction process. Now, if the tenant has engaged in illegal behavior within the property, the landlord could issue a 3-day notice to vacate. Remember, the police have to be contacted if clear proof of illegal activity is found. Example of illegal activities include, but are not limited to, involvement in the creation, distribution, or consumption of illegal drugs, subletting without the landlord's approval, or theft, violence, and assault. Landlords are advised to keep a close eye on their tenants to make sure illegal behavior does not go unnoticed. So in this case, tenants are not allowed to renew their lease, and the landlords have to issue a 30-day notice to vacate. The tenant then has no choice but to leave the premises before the end of the notice period. And then landlords can continue with the eviction process if the tenant refuses to leave after the 30-day grace period. So in Texas, landlords cannot evict a tenant or force them to vacate the property without probable cause. So as long as the tenant doesn't violate any rules, they can stay until their rental period ends. But if the tenant stays in their rental property even a day after their lease agreement ends and has not arranged for a renewal, then landlords can issue a 30-day notice to vacate. It's also worth noting that landlords are not obliged to remind their tenants to renew unless stated in the lease/rental agreement. So the whole eviction process can only begin after the issuance of the notice to vacate. The landlord must have allowed enough time to pass before filing for the eviction. But the eviction process is as follows. First, proceed to the justice court that the rental property belongs to. Then, file a forcible detainer suit and prepare the following information for the quickest experience possible. Have the tenant's name and contact details, the landlord's name and contact details, the location and description of the rental property, the reason for eviction, details about the tenant's stay in the property, action taken with the notice to vacate, pending fees owed by the tenant, and the tenant's involvement in the military if applicable. It reduces the scheduling of the hearing from 20 days down to 10 days after the filing is passed. If the landlord wins the case, the repossession of their property is then fast-tracked. If this bond was filed, the landlord has to provide a notice of request to the tenant. And do note that filing it is risky because if the tenant wins, then the money spent by the landlord goes to the court fees of the tenant. So in Texas, filing fees can start as low as $46, but they can go upwards of past $100 with an additional $130 for the writ of possession. These prices are going to vary from county to county. So all in all, it takes about 3 to 30 days from the issuance of the notice to vacate, depending on the reason for the eviction and the lease agreement. However, filing should only take 1 day at most, barring any delays within the Justice County. So before filing an eviction with the court, you need to issue the tenant a notice to comply. You can either download a free PDF or Word template from our website, or you can use a step-by-step wizard that'll walk you through the entire process. Now, this is just to help you make sure that you're submitting the legally correct notice. And I'd be remiss if I didn't say that the step-by-step wizard does in fact ask you to pay a small fee at the end, but that is a small price to pay to ensure legal compliance and protection. So when it comes to serving, an official from the court will deliver the summons for the hearing and the complaint to the tenant. This is something that's usually assigned to the county sheriff. However, there are several methods to accomplish this. There's personal service, where the court official delivers the summons and complaint to the tenant in person, or there is the substituted service, where if the tenant is unavailable, someone living with the tenant who is over the age of 16 can receive these documents. If none of these methods are possible, then the court official will turn to posting and mailing. So the server will mail the documents via first-class mail, and when using this method, the court official leaves a copy of the document for the tenant. It is placed in a secure and visible position by the entrance of the tenant's rented property. And remember, landlords are not allowed to serve the tenants themselves. This is why there is an additional server's fee which you have to pay. The tenant then has at least 6 days to prepare for the hearing and respond to the summons and complaint. The documents should be served to the tenant at least 6 days before the hearing is scheduled, and either the tenant or landlord may request to postpone the trial for a period not exceeding 7 days. So you, as the landlord or property manager, have to have a strong argument backed up by solid evidence against the tenant. However, if the tenant just doesn't show up, then you win by default. However, if you do not win, then you can still appeal within 5 days post-judgment for reconsideration. So in the state of Texas, a reply from the tenant is not necessary for a court date to be scheduled. They only have to show up for the hearing. If the tenant disagrees with the summons and complaint, then the landlord can choose to settle with the tenant outside of court. If they come to an agreement, the landlord files for a non-suit. This is really just a request for the dismissal of the case. But if an agreement is not reached, then the responsibility of providing evidence, well, that falls on the landlord, and the landlord needs to support the claim and show it during the hearing. Now, this could include but is not limited to the following: a copy of the deed and the lease, rent receipts and ledgers, bank statements, witnesses, or photo and video documentation of the violations, correspondence, etc., etc. Now, like I said, if the judge rules in favor of the tenant, then the landlord has 5 days to appeal the ruling, but that also works the other way around. As far as timeline goes, a hearing is then scheduled 10 to 21 days from the filing of the complaint, but this can be shortened to as little as 10 days if the landlord has filed for an immediate possession bond. So what next? You won the case, now where do you go from here? Provided the tenant does not appeal for a reconsideration, a writ of possession is issued no less than 6 days after the winning of the case. The writ of possession gives the tenant a maximum of 24 hours to vacate the property. Now, if you filed for an immediate possessions bond, then the writ of possession is created beforehand. The tenant then has 7 days from the time they receive the notice of request to move out should the landlord win the case. So the sheriff or constable will post the writ of possession on the property. This is to inform the tenant that they have 24 hours to vacate the premises with their belongings. And once those 24 hours are up, the sheriff or constable is allowed to remove the tenant by force. If the tenant refuses, they will be arrested. Now, there's a little caveat here. So the sheriff and constable are not allowed to remove the tenant if there is bad weather. So this includes things like rain, sleet, or snow. If this happens, they must wait for better weather before taking the tenant outside of the property. So the timeline for this part of the process is the tenants have 24 hours upon posting the writ of the possession to move out of the property. So let's look at overall timeline. On screen, there's an average timeline for the complete eviction process. This timeline does not include special cases such as requests for an appeal or the effects of an immediate possession bond. So feel free to pause, screenshot it, get familiar with it, do what you gotta do. But on average, it'll take anywhere from 21 to 60 days for the complete eviction process. And remember, you are not allowed to be the one that evicts the tenant by force. Just leave that job to the authorized official. If an immediate possession bond was requested, then the hearing would take place at least 11 days earlier. And if either a tenant or landlord applied for a rejudgment of the case, then an additional 5 days could be added to the entire process. So let's talk about showing evidence. If the tenant disagrees with the eviction request and they reply to the court, then it is incredibly important that you keep extremely good records of everything that you can to provide proof to the judge and win your case. And I mean it when I say it that this part can really make or break your entire case in the event of a dispute. You could keep a physical paper trail, but this gets pretty hard to search through, it takes up a lot of storage, and things could get lost or damaged pretty easily. So the next step up is scanning your document. You can find a ton of scanners between $300 and $400 that'll get the job done. And then once you're finished scanning things, back it all up. Store and back up everything on things like Dropbox, Google Drive, OneDrive, or any other software that's easy for you to use and search through. Or put it all together and just use a property management software. You can use these to save everything from lease agreements to signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, anything you can imagine, you can save here. You can literally just scan everything right into your software. If the tenant doesn't pay rent, and they dispute the claim, it's important to show the judge the following. Show them your lease agreement, the terms of the agreement, when rent is due, and any penalties for late payment. And then show them all of the payments, all of the previous payments, how they were made, was it a check, was it a credit card, ACH, and what date they were normally paid on. And then show them any payment returns. If their checks bounced, their bank account had insufficient funds, or they did a chargeback dispute on their card, show this all to the judge so that these charges could also be included in the dispute. Also, show any fees that your bank may have charged you and any penalties that you are owed according to your lease agreement. And last but not least, show them all your messages. If you sent your tenant automated or manual payment reminders by text, email, letter, or mail, it's pretty important to show this. And while it's usually not needed, it's still good to show that they were aware of the situation and they were given time to cure and make a payment. This is one of the reasons it's better to always have everything in writing instead of relying on phone calls and face-to-face meetings. So if you're evicting your tenant for lease violations like noise complaints or unauthorized pets, it's important to show proof using any of the following methods. If you have security cameras and a surveillance system that can show them committing the crime or lease violations, it's pretty safe to say you will win the dispute. But if you don't have that, then the next best thing you can do is record a video on your phone of any of the damages or lease violations. And of course, don't forget about taking pictures. Even if you take a video, it's still important to take pictures and show the judge any pictures, as it's usually easier to see by email or when it's printed. And once again, show them the lease terms and show them which term they violated within their lease agreement. Now, if the violation is bad enough, you might not need to have it written in your agreement, but for the future, you should always add all of these violations and contingencies within the agreement to avoid future conflict. No. You see, a landlord can be sued for a forceful eviction of a tenant if they skip the proper eviction process. So in the state of Texas, tenants can sue their landlord for the following amounts: civil penalty of 1 month's rent plus $1,000, actual damages, court costs, or reasonable legal fees. And as another consequence of forceful eviction, the statute allows tenants to stay in the property. So constructive eviction, otherwise known as a self-help eviction, is illegal. So this includes but is not limited to things like cutting off the tenant's electric, water, and heat, changing the locks to prevent the tenant from entering the property, or vandalizing and destroying the tenant's property. So according to Texas Civil Code, you may be liable for the tenant's court costs and attorney fees. But like I said, the statute also gives the tenant the right to stay on the property. And then again, the tenant can sue you for actual damages plus violations, and tenants may ask for an injunction prohibiting any further violation during the court action. Thank you so much for watching. I hope this was helpful. If this is something that you're going through, be sure to check out this playlist where we go over landlord-tenant laws across all 50 states. Thank you so much for watching. Subscribe if you haven't already, and I will see you in the next one.